Cross-border inheritance disputes involving Vietnam rarely begin with hostility. They begin with ambiguity, unclear wills, uncoordinated jurisdictions, unexamined forced heirship exposure. Litigation is usually the symptom, not the cause. Vietnamese inheritance law, land law, and corporate law operate within a civil law framework. Foreign estate planning assumptions do not automatically integrate into this system. Without alignment, conflict becomes procedural inevitability. The first structural step is mapping jurisdiction. Where are the assets located? What is the nationality and domicile of the testator? Which legal systems may assert authority? Litigation risk increases when this mapping is ignored. In multinational estates, mandatory legal provisions in each relevant jurisdiction must be identified early. If Vietnam is involved, compulsory heirship protections and land law restrictions may operate regardless of foreign testamentary intentions. Estate planning should be structured with these non-derogable rules in mind. A common litigation trigger is mismatch between asset location and governing document. Real estate in Vietnam should be addressed with explicit awareness of Vietnamese succession rules. Generic global wills invite challenge. Separate wills for Vietnam and other jurisdictions can reduce procedural friction. Each will operate within its domestic legal environment. Coordination prevents accidental revocation or contradiction. Compulsory heir protections under Vietnamese Civil Code apply to minor children, adult children without working capacity, the surviving spouse, and parents of the deceased. These statutory entitlements cannot simply be ignored through drafting technique. Failure to account for them is a frequent source of cross-border litigation. For foreign investors holding Vietnamese companies, inheritance is also a governance issue. Shareholder agreements, buy-sell clauses, and wills must align. Unstructured succession destabilizes control. Litigation risk increases when ownership records are unclear. Ensure land use rights, corporate shares, and bank accounts reflect accurate legal ownership. Registration clarity reduces contestation grounds. Ambiguity fuels disputes. Clear drafting, precise asset identification, and legally compliant execution reduce interpretive conflict. Technical defects often become litigation leverage. Cross-border estates fail at procedural detail. Proper apostille or consular legalization and certified Vietnamese translation should be prepared in advance. Post-death scrambling increases vulnerability. Lifetime asset transfers, corporate restructuring, and governance arrangements may reduce future inheritance complexity. However, such structuring must comply with Vietnamese civil, tax, and regulatory principles. Planning that conflicts with mandatory rules may be subject to legal challenge. Choice of law clauses in wills may influence succession of certain movable assets. However, they do not automatically displace mandatory Vietnamese rules governing immovable property located in Vietnam. Over-reliance on foreign governing law provisions often creates misplaced confidence. In many disputes, heirs cannot locate original wills or corporate documents. Secure but accessible documentation prevents procedural breakdown. Administrative discipline supports legal certainty. Blended families, second marriages, and overseas heirs complicate succession. Estate planning must account for emotional and legal realities simultaneously. Ignoring family dynamics magnifies litigation risk. Structures that are transparent and legally coherent reduce adversarial escalation. Heirs are more likely to negotiate when documentation is clear. Ambiguity incentivizes challenge. Foreign ownership restrictions and investment licensing may affect inherited business interests. Failure to plan for regulatory compliance can invalidate intended transfers. Litigation often begins with regulatory violation. Cross-border estates involve reporting obligations in multiple jurisdictions. Unexpected tax exposure frequently triggers disputes among heirs. Integrated planning reduces post-death financial shock. Effective cross-border estate structuring begins with mapping relevant jurisdictions and identifying mandatory rules. Wills must align with asset location. Corporate governance documents should reflect succession intent. Documentation must remain accessible and legally compliant. Proactive alignment is significantly more efficient than reactive defense. Cross-border litigation involving Vietnam is often the result of fragmented estate planning rather than unavoidable conflict. Where legal systems are coordinated deliberately, inheritance becomes structured transition rather than adversarial process. For multinational families and foreign investors, continuity depends on respecting jurisdictional boundaries in advance. If your estate spans Vietnam and other jurisdictions, do not wait for conflict to reveal structural weaknesses. Effective cross-border estate planning requires alignment between inheritance law, land regulations, corporate governance, and mandatory heir protections. To design a legally coherent structure that minimizes litigation risk and preserves long-term control, contact LTS Law at lts.com.vn. In multinational estates, clarity is not accidental. It is engineered.